Welcome to our program on immigration and you. I am your immigration attorney Michael Fulvani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael.
So let's start with the cutoff dates for the month of January 2016. The family first preference, which is for the unmarried sons and daughters of US citizens who are over the age of 21, advances by 6 weeks to May 15, 2008. The family 2A category, which is for the spouses and children of green card holders under the age of 21, also advances by 6 weeks to August 1, 2014. The family 2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, it advances by 4 weeks to April 1, 2009. And the family third preference, which are the married sons and daughters of US citizens, also advances by 4 weeks to August 1, 2004. And the family fourth preference, which are the brothers and sisters of US citizens, also advances by 4 weeks to April 22, 2003. Now, the employment preference categories, the first preference priority workers is current for all the countries including India. The employment second preference advanced degree holders is current of most of the countries, but for India it advances by 8 months, which is good news, to February 1, 2008. The employment third preference, which are the professionals and skilled workers for most of the countries except India, is October 1, 2015, and for India it advances by 4 weeks, and for India it advances by 3 weeks to March 15, 2004, same thing with the other workers category. And the fourth preference, which are the special immigrant and include the religious workers also, is current for all the countries. And the fifth preference, which are the investor category, is also current for all the countries. I think China probably is still backlogged. Okay, now if you recall, last time in our last program we did explain to you that the Department of State has now started providing us 2 separate bulletins. Bulletin number 1 is what the movement of monthly basis is that we just talked about, plus they have another bulletin which says that if you are in the US, you are eligible to adjust the status. You do not have to necessarily wait for that date, and they are the different dates they advance kind of a year or two earlier, that you could also file a 485 in the US and apply for adjustment of status. So let me read to you the January bulletin of the cutoff dates for the purpose of adjustment of status in the US. Now before I give you the details, this is something that changes also, because last year what happened last month, after issuing the bulletin they said, oh, but you don't use the last months. It may be possible that it may happen. If that happens, then we will provide that information to you. But let me at least read what the bulletin says for the adjustment of status. Are you going to do that, David?
Right. Well, actually, Michael, what Michael you're explaining to our viewers is that there are now 2 charts. One is a final action chart,
correct,
and the other one is a filing chart.
That's correct.
And so on.
But that's only adjustment of status. So people, when you say filing, they get confused.
Exactly. But we don't know which chart you should use until the USCIS announces it. So what you do is you look on the USCIS website, and at the USCIS website they're going to direct us as to which chart we should be using for filing for adjustment of status for our clients in the United States.
Correct. But in the meantime, we tell what the chart says.
Exactly. Yep.
Okay.
Exactly.
This is the adjustment of status we call AOS chart, which again, when we repeat that, for the unmarried sons and daughters of US citizens who are over the age of 21, the date is October 1, 2009. Now the difference is that, let us give you an example here, that the bulletin, regular bulletin says it is May 15, 2008. But if they say that you can use this date, then even if your date is August, September 2009, you have not reached the date that we mentioned previously, you can go ahead and file a 485, and based upon that you can get a work permit and permission to travel and all that provided you are eligible for adjustment of status.
Right, and that's actually very important, Michael, because what we want to do is we want to, I think our clients are asking us, and our viewers want to know what are the benefits that they get by taking advantage of that earlier filing date.
Correct.
So number one, like you pointed out, they get an earlier EAD, which means then that they can get driver's license earlier if they don't already have it, or a social security card
Not
earlier
only
if
the
they
principal
don't.
beneficiary, even the
Family
spouse and
members,
children.
exactly. Right, exactly. And so they can get the social security card, they can get the driver's license, they can get the travel permit, and they can also take advantage of what's called AC-21 portability, and that's under Section 106C, where after they filed and 180 days have passed, then they're able to move to a new employer in what's called the same or similar occupation. And we'll talk about the same or similar occupation memo, which is recently promulgated by the government. So we'll talk about that
So let's
soon.
continue the adjustment of status bulletin. The family 2A category, which is for the spouse and children under the age of 21 of green card holders. The date is
It's going to be June 15th,
2015.
2015. Yeah.
See how much difference is that? You see, it's almost current for them. Almost current for them. So this is very good. But we'll talk about it a little later. Let me give them all the information first. The family third preference, the family 2B category, the date is December 15, 2010. The family third preference, which is the married sons and daughters of U.S. citizens, the date is August 1, 2005. And the fourth preference, brothers and sisters, it is May 1, 2004. The employment categories, first preference is current for all the countries. Second preference, as I said, current for most of the countries, except India. India, the date is 2009, July 1st, 2009. The third preference, the date is July 1, 2005, and the same with the EW other workers category, and the religious workers fourth preference, and the fifth preference is also current for all the countries. So basically, let me ask you a last question on this, then we move on to other points.
Sure.
Even if they make a change, right, they come with something, but it's going to be better than the cutoff dates.
You mean the filing dates are going to be?
Yeah.
The filing dates are going to be the idea behind it, Michael, as we pointed out in our one of our previous shows, is that this chart always existed. It was just never something that the public could see. Now what it is that we can actually see it, so we know what these dates are, and what it is it's consistent with the executive actions that the president promulgated back in November of 2014, where what he wanted to do is to add transparency to the process of allowing us to see what the dates are that are coming.
So what I was saying, that even they did the same thing last time, they may say, oh, don't use this now in January, still you use the December cutoff dates, for example.
Right,
or some other dates.
Well, what they're either going to do is they're either going to say use the actual dates that are reported, in other words, use the final action dates, or they're going to say use the filing dates. So what they did actually, as we pointed out in our earlier program, for the December dates when we reported them back in November, they said for the family-based, use the filing dates. For the employment-based, use the final action dates. So they pulled back.
A lot of people get confused with this.
It is. It's a tremendous additional layer of confusion to everyone. But I think that again, what it does is that it adds transparency to the process. So I think that the people, and there are people, as you know, Michael, some of our colleagues really spend a great deal of time trying to predict how these numbers are going to move. And I personally think that what happened was when Charlie Oppenheimer, when he comes out with his predictions, those are very, very helpful to us because Charlie Oppenheimer actually in November, I don't remember if we had discussed this in a prior program, Charlie Oppenheimer actually came out and said that we think that the Indian Indian EB2 classification is going to be moving consistently at about 6 months for the next 6 or 8 months. Well, we can see that now it's moving at 8 months.
8 months?
8 months, yeah, which is great. So now what we're doing is we're hoping that it keeps up with his actual predictions. So I think that is a better, look into the transparency crystal ball than actually the second chart. But,
Inshallah,
but it's
inshallah,
still
this will
helpful.
happen.
Exactly.
Okay, let's now move on to some other subject. Now, if you remember that we had also a memorandum from the USCIS about some changes in the extreme hardship. So in that subject, first of all, whenever a person goes and applies for an immigrant visa or visitor visa or whatever, sometimes they deny the visa under section 212A6C or 6E or any other provisions because of a fraud or misrepresentation, smuggling or other issues. And in those cases, there are also waivers available. So basically, people get confused. What am I talking about? Smuggling. What am I talking about? Fraud or misrepresentation. So why do these things happen? First of all, let me go over some of the things that we have seen. I have seen a person who changes the birth date of the son. In other words, does not use the original real birth certificate, gets another one with a different date so that the child is not left behind and can get the visa. I have seen cases CSPA. There's a fraud there because they give a false birth certificate. They also marriage fraud. We have seen people have a marriage fraud. We have seen a divorce fraud. I don't know go more details in that because we already talked about many programs. I just want to go back later on to the hardship issue. So this comes out of the fraudulent marriage, comes out of the fraudulent divorce, and then because why did you do it? So one travel agent told me or a neighbor told me, and sometimes there is pressure from family also. The grandfather says no other son's name you put in here also and all that. And then somebody was here before illegally. He doesn't mention about that. A 9B. The council said, did you not overstay? And he catches them. Then he gets two things he gets. He gets a 6C and also a 9B. So these are some of the reasons this happens. But we always tell, please don't commit fraud. And this is very serious. Now, let's say somebody has done it. Now, this is the main thing we are talking about today. Somebody has done. So it's end of the world. It's not end of the world because there are waivers available. Waivers hindi mein bolo to maafinama available based upon certain grounds. First requirement is that you must have qualified relatives. So basically, you should have either a spouse or a parent. No children are counted, but they may now in the new memo.
Right.
But under the existing, what I'm saying. So that's one of the requirement. The second requirement is that if the visa is not granted, it is going to cause extreme hardship to a US citizen or a green card holder, parent or a spouse. So basically this, but now there's some changes taking place. So I'm telling you now what is the change now in this. I believe basically we're talking about extreme hardship and also in some way taking into consideration the other children or other family members that are the beneficiary himself also.
Okay, so in the 2 minutes that remain, I'm going to try to cover a 28-page memorandum that was promulgated. Well, it's hard actually to cover it all. I think that it's again it's a 28-page memorandum that's out for comment. The comment period is actually still open on the extreme hardship, but I think that to boil it down, really in terms of the definition of extreme hardship, not much has changed from the prior legal cases that we have. But what this memorandum does, which I think is really great, is that it objectifies. It gives us sort of a point-by-point organized fashion in which we can deal with extreme hardship. And so what they do specifically is they look to, they lay out what could be considered extreme hardship in certain cases, and I think that what they do is they draw lines in the sand, which is really helpful for us as attorneys because we can guide our clients in a better way with some objective way to look at these very subjective terms. So, so that I think was something that was tremendously helpful. But I think that what's really, really important for all of our viewers and our clients to know is that this extreme hardship memorandum emanates from President Obama's executive actions. And this is something that he also had in a memorandum back in November, and he said, I need to clarify what is considered to be extreme hardship. And you hear me keep coming back to how the president's executive actions have taken shape over the time. And the reason why I want to point that out and why that's so important is because this, I guess, in a way, lends itself to challenge the same way that Fifth Circuit case does. And yet,
so in a way, it's a good news.
It's great news.
But
it's
not
great
an
news.
effect. It's only at this point.
At this point, we're waiting for it to be finalized. Exactly.
All right, we're running out of time today. Thank you very much, David, for being on the program, and thank all of you for watching the program. Please keep watching us every Saturday and Sunday at 11:45 a.m. Thank you and bye.